Kia ora tātou. We'll just give it a couple more minutes. I can see a few more participants filing into the virtual lounge as we're talking, so let's give it a couple more minutes before we start. All right, let's begin. Kia ora tātou, ko Helen O'Sullivan, toko ingoa. Ko aho te kaiwhakahaere mātua o Crockers Property Group. Nana he nui kia koutou. Good evening, everyone. My name is Helen O'Sullivan. I'm the CEO of Crockers Property Group. It's fantastic to have you all here with us this evening. Ko Victor Jamison tēnei, mentia mātua o Crockers Community Living Management. I'm really pleased to introduce Victor Jamison, General Manager of our Body Corporate / Community Living team. Good evening, Vic. Kia ora.
Good evening, Helen. Great to be here. Good evening, everybody. Thanks for joining us this lovely evening.
Thank you all for joining us here this evening. We're finally getting back to our original seminar program after a wee detour into level 4 lockdown and back up through the levels. So our first session tonight, we're going to take a whistle-stop tour through the basics of community living entities. First up, what the different entity types are, how they're different, why that matters, how that affects what you pay as a member of that community and how that is shared out. We'll talk about how the rules are made, basically who's really in charge around here, and then when people don't follow the rules, what happens next, how that's resolved. We will also talk about the different roles in the community structures and how they're filled, and again, who tells whom what to do once that's in place. That should segue quite nicely into a discussion around the elements of a successful community. And then we will have a guide to the jargon, which we'll have on screen, but we will also forward afterwards as well. You might have questions as we work our way through this presentation. The chat function in this webinar is disabled, but you can post questions using the Q&A function at the bottom of your screen. We'll try to keep an eye on these as we work our way through the presentation, but we do actually need to keep moving as well, so we may not get to all of them. Some of the questions may be things that we cover later on in the preso, so we'll kind of try and capture that. If we've got time, once we get to the end of the agenda, and we should have time for some of your questions, we'll scoot back and address as many of them as we can in the time that we've got available. Please be aware, if you've got a specific question that's about your individual complex, we may not be able to answer it here, and so we'd suggest that you refer that one to your account manager directly. But where we see something that maybe is in respect of a specific property but has wider application, we'll touch on it if we can. Again, our apologies in advance if we don't get to all of your questions. We do have over 100 of you in the seminar, so you know, we'll get to what we can. We will be providing you with a copy of the slides after this presentation, so don't feel you have to take a lot of notes while we're chatting. We're also recording the event, and we'll send you a link to that afterwards as well. So if you have any disturbances in the space-time continuum that interfere with your sound quality, we should have a perfect recording here afterwards. All right, so that's the admin. No instructions about the fire exits, but hopefully that suffices and said. But what's first up on our agenda?
Thanks, Helen. Let's start from the beginning. So you've referred a couple of times to community living entities. What exactly do you mean by that?
That's a really good point. Let's establish the basics first. So here at Crockers, we provide management services to a really wide range of complexes, from 2-unit blocks in the suburbs to 200-unit apartment blocks in the central city, which incorporate both commercial and residential spaces. We've got residence societies that cover entire suburbs, and we've got residences or incorporated societies that are laneways for 4 or 6 units. We've got commercial and retail and industrial complexes around New Zealand. So there's such a wide range of legal entities that are incorporated within that. The most common is, of course, the body corporate model, but that being the entity associated with the unit title model. But there are so many others. We try to use language that encompasses all of our clients, and that's the community living entities word.
Right, yeah. I have heard of the body corporate model, but what are those other entity types?
So we've got quite a few cross leases, which those are units. They're owned under an older form of community title, and it's called a cross lease. Unlike the body corporate or the incorporated society clients that we have, these don't involve a legal entity, which is distinct from the owners, but technically are essentially a collective of individuals. Some of those cross-lease properties choose to appoint a manager like ourselves to assist with collective things such as grounds and insurance. They don't have to, but many of them choose to. We've also got resident societies. Now, these are legal entities which are formed under the Incorporated Societies Act. So they are a legal entity. And these act as management entities for some community facilities, sometimes for a really big group of homes like Hobsonville Point Resident Society or Gulf Harbour, sometimes for a pretty small group like a laneway society, and sometimes for a group of complexes where, say, 4 or 5 bodies corporate share facilities which are collectively managed, and the resident society provides that umbrella entity to manage those facilities. And just in case that wasn't enough to keep you busy, we do have a couple of entities which are company structures, so legal limited liability companies, where they perform a fairly similar sort of function through that company structure. The thing that they've all got in common is that there are some facilities or property which is enjoyed by the owners in common with one another. So we refer to that wider group of entities as community living entities. And within that, we mean all of the legal forms that these bodies can take on. It's a bit of a mouthful, but it's language that we use with an intention to include all of our clients.
Right. Okay, thanks for that. That does clarify a few things. Can I just go back up to a step there, Helen? What exactly is a body corporate, and what does a body corporate do?
Okay, so when a multi-unit title, multi-unit dwelling's developed, it's often, in fact these days usually, is going to be on a form of land title we call unit title. That's often also referred to as strata title, and the terms unit title and strata title are used pretty much interchangeably. In such a multi-unit dwelling, you'll have some property which is common to more than one unit in the complex. For example, an apartment building might have a lobby and a roof. Well, definitely needs a roof. Things have gone badly wrong if it doesn't. It may have a lift, parts of the building envelope, and those will serve more than one unit. That type of property is called common property. That is, it's a part of the property which is owned by all of the owners in common with one another. So when the developer's creating that complex, they create and lodge what they call a unit plan. And that's the document which sets out which bits of the building are private property and which bits are common property. And then when they lodge that subdivision with Lands New Zealand, with the Titles Office, the subdivision comes into effect, the private units are created, the common property is created, and at the same time, a legal entity called a body corp comes into existence. It's a legal entity, it's distinct from the owners, but it is made up of the owners. So the body corporate owns and manages the common property in the complex.
Right, so essentially as an owner, I am the body corporate?
Correct, you are the body corporate, the body corporate is you.
Okay, cool, thanks. So now that we know what the legal forms are and what the legal framework each one sits under, why are the differences in the legal framework so important?
It matters a lot because the legal framework that underpins each entity type creates some subtle variances and some quite fundamental things like how membership comes about, who is responsible for insurance and whether or not that's mandated, how rules are made and enforced, and of course the big one for many people is how costs are allocated to owners within each entity. On the screen, you can see a summary of how those first three items are set out for each of the entity types. We'll cover the costs in just a moment because it's a slightly bigger topic and it needs its own screen.
What do you mean, though, about how membership is enforced, Helen?
So that's kind of how you know you're in the club, really, so to speak. In a body corporate, by virtue of owning a unit titled unit, you're automatically a member of the body corporate, subject to the rules, having to pay the levies and having all the rights and responsibilities of membership in that body corporate. Once or twice we've had people buy into a body corporate and then send a polite wee note back with the levy notice saying, we don't want to be part of your club anymore, thanks, which just kind of isn't really how it works. So essentially, if you own a unit in the complex, you're automatically and irrevocably a member of the body corporate until such time as you sell your unit.
Right, well, that's important to note then. What about these incorporated societies and company title structures?
So in the community living context, when a complex is built on a fee simple title, but they've got access to some form of shared facilities, and for one reason or another, the developer doesn't want to use the unit title unit title approach, they often create an incorporated society that owns and manages those communally used facilities. Some really common examples are laneway societies. So the laneway society owns and manages a driveway, which a number of the homes need access to in order to get in and out of their homes. Resident societies normally serve a bigger number of homes, like almost a suburb in many cases, and they'll provide some form of community amenity which homes in that area share. Really good example of that is Hobsonville Point Resident Society.
Right, gotcha. How would I know, though, that I was meant to be a member of one of these societies?
So the title of the property will include what's known as an encumbrance. That's a legal device that means there's an obligation that the current owner and all future owners of the property must be aware of and fulfill. Encumbrances don't always relate to community living entities. In fact, more often than not, there are things like an obligation to allow someone to cross your property or an obligation to pay money like a ground lease. However, in the case of these community living entities, the encumbrance will require that the owner of the property is also a member of a laneway society and, in many cases, also of a resident society, and abide by all the rules and all the obligations of being a member of that society.
Right. So as an example, if I own a property in, say, Hobsonville Point, even though it looks like a normal standalone home, I might well have an encumbrance on my title requiring that I'm a member of a laneway society and the Hobsonville Point Resident Society. Is that right?
Yeah, that's exactly right. In fact, just to add to that complexity, it's also possible that you might own a unit titled property in Hobsonville Point that is part of a laneway society. So you could be a member of the body corporate and a member of the laneway society and a member of the Hobsonville Point Resident Society.
Jeepers, that's a lot of memberships. I can see how someone might get confused. Okay, so the membership point may not be obvious at first, but presumably that gets explained to me by my solicitor on the way through my purchase. What about how things are done after I'm a member? Does that change at all?
Look, it can do. Look, to your first point, yes, it absolutely should get explained to you. If your solicitor is doing the job property on your way through the purchase process, you really should have this explained to you on the way through. It's part of your due diligence, really. So the key thing that kind of changes after you're a member, if you're part of a body corporate, there is a dispute, and say there's a dispute between members of the body corporate, like one of the owners thinks that the body corporate's applying the rules incorrectly, or they're in disagreements about whether or not that corner of the courtyard is mine or common property. Either the body corporate or the owner can apply to the tenancy tribunal for a hearing on the issue, and that's because the bodies corporate come under the auspices of the Unit Titles Act. They can apply to the tenancy tribunal for a hearing on an issue that's in dispute. Not super cheap, filing fees for complex issues, or what they call Category 1, cost $3,300. And filing fees for less complex, what are called Category 2 issues, are $850, and issues regarding payment of levies fall under that heading as well. So, but it's not super cheap, as I say, but there is at least a body to whom you can take these disputes for resolution. And sometimes they're not disputes about money, they're disputes about pets or where the parking is, or that kind of thing. With incorporated societies, you can try the disputes tribunal, but we've had really mixed luck with the disputes tribunal, particularly where it relates to an issue which is not sort of money based, and things like someone parking where they shouldn't, or someone keeping a pet which somebody else doesn't think fits within the rules, or is too big or too dog-like for the rules, whatever the issue is. The disputes tribunal often isn't that effective for dealing with those kind of issues, but it's the only mechanism other than the courts we have available to us when trying to resolve those issues within resident societies, cross leases and the like. That's terribly expensive, of course, if the court gets involved. Same applies to cross leases, with the added complication that you're really dealing effectively with issues of individuals, not entities, and the ability to enforce the debts really relies on the detail in the cross-lease documents. The cross-lease documents are all completely different from one another. They tend to be quite old-fashioned, and they're often just not written to deal with the modern circumstances that we find coming up in sort of 2020 community living. So ultimately, the courts can be the only recourse, and there's a very famous judgment in the High Court about what constitutes a small pet, and you can hear the disappointment in the judge's voice as they reflect on the years in law school they needed to become a judge and opine on small pets. But sometimes it's the only way.
Right. So that's quite an important distinction to be aware of then. Right, so we've covered off the legal framework, membership, and disputes. What about the thing that's at the root of many of the questions that we get, which is around costs? How are these set in the different entity types?
Yeah, so this is a big one, of course. Look, even though the costs are called different things when they're invoiced to owners, a body corporate, they're generally called levies, generally called membership fees in a society. Fundamentally, there's a pretty consistent sort of a concept that underlies each entity's approach. Firstly, each entity has a set of costs that it has to cover each financial year. We develop a budget for those costs. That is then reviewed and approved by committees, and then ultimately reviewed and approved by all the owners at an annual general meeting. Then that total budget, those costs, get allocated to each of the owners in the complex by some kind of formula, and we'll deal with the detail of those in a minute. It's really important, though, as a first step when we're talking about that budget, to note that it's set by the owners, and that's based on the things that the committee, which is elected by the owners, or the owners directly in a smaller complex, have decided that they want to do, that they want to fund for the coming year. That's what drives the total budget. Obviously, that total budget drives the levies that the owners have to pay, as well as what is provided in and around the complex. So as an illustration, we've been asked about a property where there's two blocks side by side, developed at the same time, roughly the same time. Each block has its own body corporate, so the two separate bodies corporate, even though they sort of look quite similar. And there's obviously a different committee in each of the two bodies corporate. We've had an owner sort of note, one block's had 3 building washers since a certain set of renovations was completed, and the other hasn't had any. Crockers of the BC managed secretary for both of them, and so the owner's kind of wondering why does one block get 3 washers, the other one doesn't get any? And the answer is that there's 2 different committees in those 2 blocks who are taking quite different approaches to the way they run the complex. So the budget that they set and what they actually want to fund around the building. Ultimately, it's the committee and then the owners that decide what that budget is and what's done. You know, we might suggest a building wash, but if the committee elects to remove it from the budget, then there's no funding for it, and it's not something that gets carried out. So if you as an owner want to see your body corporate do something, like get the building washed more often or spend more money on landscaping and cleaning, if that's of value to you, then you need to get involved in your AGM and possibly even your committee to get that addressed. So we'll talk about this a little bit more when we get to what makes a successful community. But that's the key point that drives what's in the budget and what gets done.
Right, okay, so that's good to know. So basically, the community decides what it's going to do, or just as importantly, not going to do, and that drives what the total costs are going to be. Once the total costs have been calculated, each owner pays a share of those costs. I think I've got it. So how is my share worked out? Again, starting with the body corporate.
So in a body corporate, the utility interest of each unit is expressed as a percentage and then multiplied by the total value of the annual budget. Each unit will have its own utility interest. That's set out in the title of the unit and in the unit plan. Can be varied, but it's quite a process. So if it's happened in your visa, you'll pretty much know about it. And there's a bunch of rules, again, in the Unit Titles Act around fairness, approval, blah, blah, blah. What is important to point out, though, is that the body corporate's costs and activities are only in respect of the common property, because a body corporate only has powers and responsibilities in respect of common property. It can't raise money to do stuff which is private, and it can only exercise jurisdiction in respect of stuff which is common property, which is a thing that exists to manage.
Right, only common property, got it. So not the cost of running your own personal apartment. As owners, we'd still have to pay for our own power, phone, internet, etc. And many other complexes, water as well. And how might that be different in a shared lane or a laneway society?
So the basic concept's the same. An annual budget gets worked out and then the owners approve it. And that covers the expenses of the entity of the year. Maybe some provision for future costs, but by and large it tends to be just current stuff. The difference is that the formula for allocating those costs to members is going to be set out in the rules of the society, as opposed to being driven by the utility interest as we saw in a body corporate. So for laneways, which are usually relatively small, it's often even shares. So just an even split based on number of owners. For the larger resident societies, it can get a lot more complicated. For example, Gulf Harbour has a number of asset classes. Some owners are in those and some are not. And so there's a very specific formula relating to each asset class, which again is driven by the rules of the society. And then the Hobsonville Point, McLennan Park, which are both resident societies we manage, they just have a flat fee per owner, which kind of covers roughly what the anticipated activities for the year are. And look, for cross leases and company titles, there's just no one rule. It's all totally specific to the complex and what it is and what it does and what it doesn't do.
Okay, that's quite complicated to follow. Have we got an example we can use to illustrate that?
Sure thing. Look, on your screens at the moment is an example of the budgets of one of our body corporate clients. And you can see that there's three elements to the building's total budget for the year. First one's the operating budget. Now, obviously, there's another piece of detail behind this, which is the list of about 20 different items that are covered in that body corporate's budget for the year. But the operating portion of it comes to just over $222,000. Then there's another portion, which is about $44,000. That's the reserve fund contribution, or the contribution to the long-term maintenance fund. Then there's another sort of one-off contingency for unexpected costs that might pop up during the year. That adds up to a total of $277,217.42, as you can see in the resolution that's on the screen. And that's the total budget for that BC. The next slide shows a unit in that building, which has a utility interest. It's expressed in our current tool as 231,000 out of 10 million. But that equates effectively to 2.31%. So the levy that's payable by this owner is equal to 2.31% of that total budget. So the math for it is there. Ultimately comes to $6,406.50, and that's what that unit owner will have to pay towards the cost of that BC for this year.
Great, thanks, Helen. That was helpful. And what about if that were the budget for, say, a shared lane where the budget is split by even shares?
Sure. So say, I won't use that number because it's that would be a pretty scary budget for a laneway, quite frankly. Costs of running a big building, like the example we used before, are quite a lot more extensive than a laneway. But look, just as an example, if we had a budget of, say, $7,281, and we had 20 properties in the laneway, or 20 members in the society, the budget being allocated by even shares would be 1 divided by the total number of properties times the total budget, or 1 divided by 20 times the budget gives you that, each individual member and their levy for the year for the BC. The fundamental concept is much the same. Total costs are, in fact, exactly the same. The total costs of the entity are shared amongst the owners of that entity, just a question of how it's allocated, whether it uses the Unit Titles Act mechanism or another one that's established by the rules of the entity.
Right, so it's really important to understand how those costs are allocated, and you're saying we need to read the rules of the particular entity to get a check. So yeah, I think I've got that. So what happens when somebody doesn't pay their levies or their fees? If I'm hearing you correctly, the body corporate or laneway has costs that it has to pay each year. If someone doesn't pay, the entity has the same costs but not the same income? Isn't the entity going to run short of cash?
That's exactly right, Vic. Look, in essence, when you don't pay your body corporate laneway, your body corporate levy or your laneway fees, you're effectively asking your neighbours to help cover your costs for you, which can get a little awkward. Making that recalcitrant owner pay up is our task, but it's not an easy task, and it also doesn't come cheap. If owners don't pay, there's a debt collection process that we first institute. If that doesn't produce results, we have to go to the tenancy tribunal for body corporates, or for a laneway, etc. We go try the disputes tribunal, and or ultimately sometimes we have to go as far as the district court. There has been a question pop into the questions down here asking, somebody's asked that they've said they have a complex that's undertaking a roofing project that they've been advised is going to cost millions. Do I have to pay extra levies? And the answer is yes, that's going to be, broadly, if the concept is fundamentally, if the body corporate has costs, the only way those costs are funded is through the owners contributing money to pay for those. So, it's possible where you have a major project that there could be somebody who can be sued, but funding the cost of suing that person and funding the repairs in the meantime is something which will fall on the owners. So, yes, if your body corporate has additional costs like that, it is the owners who will need to pay the levies in order to enable that work to be done. Going back to the agenda, look, all of this, and look, the remedial projects are where we often see the biggest issues with regard to debt collection. The reality is the debt collection process costs money, and the entity has to fund both the debt collection costs and then that gap in funding that exists while you're pursuing that recalcitrant owner or owners for their portion of costs that haven't been paid. Unlike a normal commercial situation where you're providing widgets and I just stop giving you widgets until you pay me money, you can't actually stop. Unfortunately, you can't stop providing the roof to somebody who is not paying their bills. So it can create a huge amount of stress for other owners and for committees, and it can lead to some pretty protracted disputes as well.
Yeah, I imagine that gets pretty tricky, all right. So we've talked about costs. The other thing we hear a lot about is rules. I take it that everything else that like everything else that we've talked about, there are some similarities, but also some subtle differences in how these come together.
Absolutely, you're onto it. Look, once again, there's a fundamental sort of a concept The entity starts out with a set of rules that are made generally by the developer when the entity is being formed. That gets it started, and from there on in, with one exception, owners can change the rules to work for their complex up to a point, and obviously still within the legal framework. You can't resolve things that are illegal for fairly obvious reasons. So look, for a BC, the rules are called operational rules. They're set initially when the developer owns 100% of the complex, but they can later be varied by a resolution, an ordinary resolution at the body corporate's general meeting. Rules, though, let's note here too, they do have to be about the common property. So we've had somebody ask whether or not you can stop a certain type of person living in the complex. And the reality is no, because you don't have the power to make rules about things that aren't related to the common property or the operation of the building. So, you know, rules have to be about the common property. If they're not, they can be judged to be ultra vires. And of course, the rules of the local council and of the land still apply. So a body corporate can't decide to let owners do something that's illegal under council rules. You know, for example, allow people to park illegally on the street. If it's illegal to park on the street just because the body corporate decides to resolve that it's okay, still that has no effect. It also can't make rules about private property, except where that property in some way is going to be impacting on the physical operation of the complex. So the body corporate can resolve, for example, that I can't take out the windows in my apartment if me taking out the windows would result in the balcony upstairs falling down.
Right. Okay. And what happens if the body corporate does try to make or to enforce a rule which an owner thinks is outside of the powers of the body corporate?
That's a really good question. Like, the dividing line can obviously be a very nuanced sort of thing, and it's never fun when people take up different positions on something that's important to them. So hence, we do often need the tenancy tribunal to arbitrate when there are different disputed interpretations of the rules. Again, that can be a pretty expensive and protracted experience, but at least that tenancy tribunal exists as an avenue that we can take these issues to when we reach situations where owners just can't reach agreement about, you know, that's my view, that's my view. We can't agree to differ because it matters to how the money gets allocated. We're going to have to go and get someone to, you know, make a decision for us.
Right. And what about entities other than a body corporate?
Similarly, they're established by the Incorporated Society for the Laneway or Resident Society will be formed with some initial members. There'll be a constitution which sets out the initial set of rules. Then there is in the future, again, according to the rules, will basically set out how the rules can be changed, which sounds a little bit circular, but that's kind of how it works. And, you know, there can, you know, the community can resolve at a later time to alter those rules. There is some commonality between some of those laneway societies. For example, at Observable Point, the master developer there, which was HLC, now Kāinga Order, has provided most of the all of the developers there with a common form of constitution, which is pretty much universally adopted now. But it took a while to get there, so some earlier iterations are a little bit different. Ultimately, that kind of concept is there. It's what it gets when it starts. It's formed by the developer. Later, there can be alterations if the community checks out its rules and makes changes.
Right. And if there are any disagreements within a laneway, say, I don't like where my neighbour parks their car, what happens then?
Look, this is where things can and do get really tricky. There are incorporated societies, which means we don't have that avenue of the tenancy tribunal to resort to resolve disputes, which means that we've got disputes tribunal if we can convince them they have jurisdiction, and or it can be something that winds up being taken as far as the courts. Again, it costs additional money because, you know, the additional costs of our representation, say, cost money, or owners have to put their own time and energy into actually attending those disputes tribunal hearings. So, you know, it also can be quite expensive. Tenancy tribunals not cheap. These kind of he said, she said, I say, you say, they kind of fall into $3,500 fee category. So, knows in the context of these entities, it's a pretty big chunk of change.
Yeah, shucks. So not being able to use the tenancy tribunal creates a challenge, doesn't it?
Yeah, it really does. Well, look, what it boils down to, Vic, is we're trying to use the 1908 Incorporated Societies Act to manage community living in 2020. And the reality is it's not really working terribly well in some cases.
Yeah, when you put it that way, yes, I can see how there can be an issue. So what's the answer to that then?
That's definitely a topic for another day, because I don't think we'd finish before about midnight if you let me get started on that issue. So don't let me get started on that issue. We will come back to it later in the year, I promise you that. But for now, look, let's carry on with the entities we've got to know and love so well here. Cross-lease, look, this is even more complicated. The detail of these is in the very, very fine print of the lease documents. I've never seen two the same. You need to search the title to find the detail of the cross-lease document. And changing them this is where we have the exception of the community being able to vary those documents. It is a pretty complicated process. Ultimately, other than changing from a cross-lease to a unit title, which has expenses of its own, I don't think they're terribly easy to change. And once again, enforcement relies on the courts. And again, as we said earlier, cross-lease is one where there isn't a legal entity. So it's actually individuals needing to collectively enforce against other individuals. And again, it's way complicated.
Right, okay. And what about company titles?
Company titles, they're limited liability legal entities, incorporated at the company's office like any other company you might care to name. They have a constitution, which they adopt on formation. And then again, there may well be ways that you can change that constitution, again, voting as per the rules, which are set out in the rules.
Right. So there's a clear message here that isn't there, that whatever the entity form, resolving disputes can be time-consuming and painful exercise, even more so if you're not in a body corporate, but still quite a bit of a pain. Yeah,
exactly right. Look, I guess it comes back to the word we've used a lot in this discussion, which is community. Ultimately, if you've got your own island, you can make your own rules. If not, then you live in a community of some form or another. When you live in the developments that we're working with, you are closer to your fellow humans than perhaps we've been traditionally accustomed to in New Zealand. Getting along in those circumstances does call for patience and tolerance and, dare I say it, kindness on everyone's part, because quite frankly, nobody other than the lawyers win when communities like this fight.
Yes, I concur. Returning to perhaps some more prosaic matters, what does the governance structure of these community living organisations look like?
So as we've talked about, owners are the entity and the entity is the owners. So decisions and funding all comes back to the owners for approval in conjunction with the relevant legislation. The community, which is the owners, have annual meetings and they appoint a governing committee which manages the entity during in between meetings. That committee and or its chair exercise the power of the community, generally through the agents that it appoints, such as us, as the body corporate secretary, body corporate manager, and many complexes also have a building manager, depending on the size and complexity of the complex that it's serving. Units, buildings of 60 might well have a building owner and building manager, because the cost of it's spread out through a lot of people. And some of the tasks that are involved are pretty complicated. So, it's a bit too big a job for an owner to just do in their spare time. In an entity where you've got sort of 8 or 12 units, it's a bit of a fine line because there's more to do, but the costs of having somebody do that are quite a lot when only shared by 10 or 12. So, horses for courses. But, in a lot of those smaller complexes, we see owners take on some of those tasks directly.
And I guess as we've seen through all the way through this, that each different type of entity has different names for these governance elements.
But of course, in a body corporate, you're an owner, and an INCSOC, you're a member, and a company, you're a shareholder.
And is this the same for a large or a small entity?
As long as it's the same form of entity. So a small body corporate still has owners, a giant body corporate still has owners, and so forth. You know, in a smaller entity, the owners and the committee could be one and the same. So if you've only got 4 owners, they may well all 4 constitute the committee as well. Technically, when they're exercising their powers as a committee, they're wearing their committee hat.
And what is the function of the committee?
So the committee carries out the tasks that have been delegated to them by the entity during the year in between those meetings, and then they report back on the exercise of those functions at the next general meeting. The committee can vote if it needs to on a matter, and that's based on a simple majority. But to be fair, most of the committees we work with generally work more or less by consensus without much need for voting.
Presumably some of the bigger entities, this can be quite a bit of work. Is it a paid role?
Yeah, you're right, Victor. It is a lot of work. And generally, no, it's not paid. You know, unless there's a big project being carried out where some members might be getting an honorarium or might be getting paid for some of their hours. By and large, it is a labour of love. You do it, as part of your community spirit. And, it's ultimately, as we say in the slide, they're the people that make the community run smoothly, and they deserve a round of applause and buy them a drink.
And is it the chair that heads up the committee?
Yep, that's right, for an incorporated society in any case. In the case of a body corporate, there's a chair of the BC and there's a chair of the committee.
Right, there's a chair of the BC and a chair of the committee. That's confusing. Are they not the same?
Technically, no, they are 2 separate roles. In most cases, they are one and the same person, but they can actually be 2 different individuals for reasons which can be specific to any given complex. But in both cases, you have to be an owner in order to do the job, to take the role. And that's the case with any of the committee roles. You must be an owner. I guess just reflects that to be involved in the management of the entity, you do need to be an owner. Causes some problems with when limited companies are owners in committees, but that's something we'll delve into later in the year when we talk about Unit Titles Act challenges. Ultimately, it can, this chair's role can be a really time-consuming task, and frankly, the better the BC chair, the better the BC runs. They're a key liaison point for us, key liaison point for the building manager if there is one. So fundamentally, if there's someone in your community who does, then say thank you, give them a round of applause, buy them a drink, and so you polish their car, because they do, they add a lot of value to your complex, and they're well worth any thanks you give them.
Yeah, I agree. It definitely sounds like a lot of work, and well done to those men and women that I say they do that job. So finally, if I'm an owner, how involved do I have to be in the committee or in the meetings?
Well, look, it's not compulsory. I mean, you don't get kicked out if you don't take a turn on the committee, but again, it comes back to that word we used earlier, community. You get out of it what you put in. If you want to say in the way your complex is run, if you want to get cleaned more frequently or spend more money on landscaping, or you want a working bee to clear up that really ugly corner of the grounds, it's really up to you as an owner to get involved and to lead that, because it's not going to just do itself effectively. So it's ultimately up to you as owners to decide how your community runs within the law, of course. And it's that level of involvement that really determines how successful the community is, how good the building looks, what the vibe of the complex is, and how nice it is to live there. It's ultimately, it's about give and take. We've got a few things up in the screen there about things that contribute to a community, design that gives you bump spaces of communal facilities, and social media, newsletters, etc. Fundamentally, it's about the approach. We're all in this together. It's tolerance, accepting that other people's kids have got a right to get out and play in the garden on a Sunday morning. and that people run their boats when they get home from fishing, all the things that people do that, when you live anywhere other than an island, you're going to hear and you're going to have to accept and tolerate. Conversely, you need to accept that throwing parties that run till 4 o'clock on a weeknight are really not very neighbourly. That kind of thing. Also, the council are still able to weigh in, noise control and things like that. But broadly, perhaps you don't need to get out your leaf blower at 7 a.m. on a Sunday morning, and perhaps you've just got to accept that the neighbours' kids do laugh and shriek as they run about playing on a Saturday morning. Hei waka eka noa, as we've all learned to say to each other lately.
Thanks, Helen. Those are all good points. And it's probably a good place to finish. Thanks for all the insights. It's been a great discussion. We've got a few slides on some of the industry jargon, which hopefully we haven't overused in this session. We'll slowly cycle through those, and they will also be included in the pack that we send out after this session. Just while this is happening, are there any other questions, Helen, that have popped up during our webinar?
There's a question here as to whether or not Crockers can help with securing loans for owners, or does the body corporate apply for a loan? The answer to that is effectively lending for large projects is going to ultimately be owners will need to contact their banks and work through that with their financiers. Bodies corporate legally can borrow, but practically we have tried a number of times and found it virtually impossible to find lenders who can get their heads around the context and can accept the options with regard to the leases, with regard to the legalities of it. So, fundamentally, owners will have to go to their banks themselves to borrow money for projects like that. And the body corporate will, by and large, we have found it almost impossible for bodies corporate to borrow to fund large projects. We also have a question, is building insurance included in levies? This is a really good question. So thank you, Joan, for that one. Building insurance in a body corporate is always going to be included in the levies, but it's insurance for the common, effectively the building only. So the distinction, lovely analogy one of our team always used to use, if you could pick the building up, turn it upside down and shake it, if it would fall out, then it is not covered by the building insurance. And if it stays put, then it's covered by the building insurance. So in a body corporate, under the Unit Titles Act, a body corporate is required to effect insurance. In other entities, such as the laneways and the resident societies, the answer is generally no. Insurance is not included in those. In cross leases, it depends on what the community has decided to do. It's a good idea because one of the bigger challenges that we saw in Christchurch, for example, came from sort of conjoined buildings where you might have 6 in a row and they had 6 different insurers, and the battles between the insurers have been majorly painful. So it's a great idea, but again, there's no rule that requires it. So it's up to the community to work out how it deals with that. So short answer, in a body corporate, yes, building insurance is included in your levies, but it's building insurance only, not cover for your contents. So be aware of the distinction. Okay, here's a question. Can you alter issues resolved earlier at a committee meeting at later meetings because it had possibly been incorrectly handled? I guess there's a couple of things you could do there. If you find that the committee meeting, you can change your mind. Committees can reverse decisions that they've made. It can validate decisions that have been made. But it's always got to be careful not to be ultra vires of its responsibilities. Now, that ultra vires means outside of. So if a committee's made a decision which is found later to be incorrect, say if somebody applies to the Tenancy Tribunal, there may be consequences of that incorrect decision which need to be unpicked. So, and this is why the body corporate insurance cover that we put in place through all of our bodies corporate through the Orion policy incorporates what is called directors and officers cover, so that the people on the committee have some insurance cover if you had a situation where an owner takes umbrage at one of the committee's decisions, and it later means that there's legal action that arises from that. So hopefully that's addressed the question. You can always go back and revisit stuff, but bear in mind consequences that flow from it may or may not be able to be validated as a result of a later decision. So if there is something contentious about what you're doing, it pays to step carefully because actions have consequences, and it's important to make sure you're on the right side of your protective barriers when you're making decisions that are tricky. Right, another question. Are outside cladding such as windows covered by the BC, or is it the owner's responsibility? Tragically, the answer to this is going to be, it depends. Depends on the unit plan and how that's written and how it's drawn. Generally, there will, so broad rule of thumb may be if you've caused damage to the window, you may be held responsible. The type of the window and the nature of the window in some bodies corporate, say, for example, a big apartment building, the window is covered because it's actually a structural element of the building. And so generally is part of the common property and therefore covered. In some older BCs, or it's not a structural element, it may not be. So tragically, again, the answer is it depends, and you would need to look at your unit plan and try to interpret that as to whether or not the window was in or excluded.
Right.
Okay, how much time have we got left? Another 5 minutes maybe. Tracy asked, is there a cost to a resolution to change the rules? The answer is that there's no cost per se, as in, but if it is something that is done by outside, the cost of developing the change to the rules and the cost of mediating the discussions may well come at an extra cost. So from the point of view of our secretarial fee or our management fee, it covers just a basic suite of services. If you want to change the rules, then the process of getting advice and liaising with lawyers, etc., if they're required to draft it, that will be an additional service which is charged for. Is there a cost to passing that resolution and then having it filed? No, not to that piece. There may be service fees involved in getting the work done to determine how it's done. Okay. Somebody has asked, I won't post the question, but somebody's asking a question. This is largely about whether or not their neighbour has or they perceive their neighbour to have some issues, and from time to time they scare their tenants and other residents in the building. The reality is the body corporate has no powers to intervene and perhaps declare somebody is or isn't allowed to live in a building. Unlike, for example, I think in the US, there are very complicated entrance processes where you get vetted by a committee and things like that. And people who've seen a lot of those American shows sometimes think that's how the BC works. In New Zealand, that's not how the rules work around community complexes at all. And so if somebody's an owner or occupier, then there's actually nothing that the body corporate can do other than if the behaviour is criminal behaviour, individuals can of course complain to the police, and that but that isn't something that the body corporate does or gets involved in. And it's really important. Your body corporate isn't they're not the police, they're not the council, they're not noise control, and so they will need to be, they'll, if that's, look, I know it can be, but just, again, if you're living at number 22 and the person at number 24 is problematic, then, your recourse is to the police and other services, community services like that. All right, I've got a couple more minutes. There's a number of questions here which are in respect of really specific things to do with individual complexes, and they're ones I wouldn't venture to answer without being able to actually know the specific facts of the BC. It is a fact that all unit plans are different. They come in all sizes and shapes and sizes. All complexes are different, and so a really specific question about does my body corporate have the ability to complain about how I keep my garden will depend on how the unit title plan is drawn, whether parts of the bit sit across or over or into. So I won't venture to answer some of these questions because they're really specific and in respect of an individual BC. And if I can try to give you a generic answer, it will turn out to be incorrect because you've got the 1 in 700 that has a slightly different rule. So I will pass on a couple of these. Again, there's a question here about being in a small complex and there's an end lot. I was told by the resident that the owner is not part of the body corporate. To answer that one, you will need to look at the unit plan for your body corporate. And the short answer will be, if it shows that, if the unit plan indicates that that unit is part of it, it will be. If not, it won't. Again, these things aren't always as simple as they sound. And sometimes you may need to actually go to a lawyer and get them to actually look at the unit plan and give you a view on it. Right. Okay, I think that's about the end of the questions that I can address that won't be specific to complexes. So look, and it's pretty close to, in fact, it's 2 minutes to 7. My God, I've very much used my full hour here. So look, thank you all very much for joining us here this evening. We hope it's been useful, and we really appreciate the time that you've spent with us this evening, and hope it has been worthwhile for you. Thank you for entrusting your community management tasks to us. We appreciate and try to repay your trust in everything that we do. If we can assist you with any of our other business lines like property management or sales, we'd love to have that privilege, and contact details for our new business team are on the screen now. The attachments we've referred to in this session will be included in the pack that we send out to registrants for the seminar, along with a link to the recording. I forgot to mention, but on the last slide, there's also a link to a blog post which went up today, which has a whole bunch of this jargon for bodies corporate in it for you. There will be another one shortly next week for InkSocks, so don't despair if we haven't got that one up to you yet. Look, thank you so much again for joining us this evening. I hope you found it useful. If you did enjoy the session, please take a moment to tell us that in the survey, and feel free to pass on any feedback you've got and ways we can make this better and more useful to you. So thank you all very much, and stay warm, stay safe, kia kaha.
Yeah, thank you, Helen. Thank you, everyone, for joining us. It's been a great discussion.
Kia ora. Good night, everybody.
Good night, everyone.